what you term as secular. Or
I term them as secular, non-personal.
so far, so good.
Yes.
But when it comes to personal law, this will also implicate personal law, isn't it? Because some of your
Some of them will argue, Milord.
Yes.
Menka
Now,
wants to argue.
therefore,
You don't want to. All right.
you may not argue. You have strategic reasons why you will not argue. But this court will have to engage itself once more, twice more, maybe 3 times or 4 times more.
Yes, absolutely right.
Which one of these?
Should not have.
The question is then we are not looking at it as a whole.
You have to look at it.
We are looking at it in a truncated manner, which means that we, perforce, for the sake of, let's say, convenience or clarity, we say that we confine this declaration or whatever relief you are seeking to the Special Marriage Act, right? Which means that others who do not wish to or are not aware of this form of marriage, and I use these words very carefully, who are not aware of this form of marriage, of this going through the civil form of marriage, we can't presuppose, we can't assume that everyone knows this. They are denied this, right? Either they choose their religion or whatever. If they choose to, then they are out of this. So that is one aspect. Second aspect is they intersect with personal law even here. So keep that in mind when you make this.
Yes, ma'am.
Yes. I'll tell you later. Yes. I appreciate, Milord, for your Lordship's comment. So now 469. Citizens of a democracy cannot be compelled to have their lives pushed into obscurity by an oppressive colonial legislation in order to ensure the sexual and gender minorities' fulfillment of their fundamental right. It is imperative to confront the closet and, as the necessary consequence, confront compulsory heterosexuality. Confronting the closet will entail reclaiming markers of all desires, identities and acts which challenge it. It also entails ensuring that individuals belonging to sexual minorities have the freedom to fully participate in public life, breaking the invisible barrier that heterosexuality imposes upon them. The choice of sexuality is at the core of privacy, but equally our constitutional jurisprudence must recognize that public assertion of identity found in sexual orientation is crucial to the exercise of freedom. But I submit 469 will fully apply. And instead of the words colonial legislation, we can use, Milord, the words colonial mindset. It is that mindset, Milord, which started from then. Society has evolved. Your Lordships, Milord, struck down the barrier 5 years ago. But some parts of that mindset remain, which is evident from the stand of the respondents, including that of the states. And this mindset is, Milord, is implicit in the ground or at the ground level whenever we go to public spaces and in the so-called, Milord, the secular laws which I am mentioning, which also will have to be read in accord with the declaration if a Lordship so grant the declaration. In other words, I will propose at the end, but I will just preface. Milord, wherever husband and wife is used, make it gender neutral by using spouse. Wherever, Milord, man and woman is used, make it gender neutral by saying, Milord, person. And I will give you, Lordship, examples in the Special Marriage Act itself. So kindly, Milord, note this. Husband and wife should be used as spouse, and man and woman should be used as person. A large part of this, Milord, will solve our projected interpretation, Milord, of the Special Marriage Act. And what is good here must also apply across, Milord, the spectrum, at least of the acts, Milord, the examples of which I am talking about. So that's why I said, Milord, 469 will fully apply by removing legislation into a mindset which is evident even today. Then, Milord, the Lordship terms 471. 471 talked about reputable and disreputable sex. Kindly see, my lord, the last line of that page. If one accepts the proposition that public places are heteronormative and the same-sex sexual acts partially closeted, relegating homosexual acts into the private sphere would in effect reiterate the ambient heterosexism of the public space. Which means, my lord, in other words, the rule of majority in public spaces. It must be acknowledged that members belonging to sexual minorities are often subjected to harassment in public spaces. The right to sexual privacy, founded on the right of autonomy of a free individual, must capture the right of persons of the community to navigate public places on their own terms, free from state interference. What I'm really requesting, my lord, for a declaration of marriage is really a paraphrasing of this. When I walk into a public space, I walk into the public space with my partner, knowing that the law in the state recognizes this union as a marriage. Nobody will raise a finger of stigma against me. I walk into this public space. I walk into, my lord, public employment. I walk into private employment. I walk in, my lord, for pensions, gratuities, etc.
The live court proceedings that we are getting as of now when it comes to the same-sex marriages, as this is the second day as the hearing that is taking place, on the note with the government saying that it will re-examine whether or not to participate in the proceedings at all. But we'll move on from that story. Let's